Professor, thank you very much for joining us tonight. Would like to know, how does this ruling align with Uganda's constitutional provisions regarding freedom of speech and expression, particularly for public figures like Isaac Ssemakadde?
Wow, wonderful question. And for us to, first of all, understand what the whole challenge the nation is facing, let me first of all lay bare some of these constitutional guidelines. Uganda's constitution guarantees freedom of speech and expression under Article 29(1)(a). This right extends to every citizen, including public figures, with the usual limitations found in Article 43, which restrict freedoms where they prejudice public interest, national security, or the rights of others. However, the judiciary must balance these limitations with the constitutional principle that restrictions on fundamental rights must be necessary, proportionate, and justifiable in a democratic society.
Christopher, what are the chances of Ssemakadde's appeal succeeding, and how may the Court of Appeal's decision impact his tenure as the president of the Uganda Law Society?
Quite an interesting question also. This ruling, first of all, has set a precedent in terms of future cases involving public figures in terms of critiquing the government or even causing potentially chilling effect. I would argue that the possibility of appeal is there. In a sense, especially if there were arguments that can be propounded in terms of the proportionality of the so-called punishment. Yes, the proportionality given the severity. How about the instance of exploring other options where there are no other options? For example, in terms of penalties, in terms of what? Substantive what? Rebukes rather than extended punishments in terms of 2 years. We have to understand that, first of all, Article 19 of the ICCPR, which Uganda ratified, judiciary must be very careful not to suppress democratic engagement. And the chances in as far as the appeal to succeed are significantly high. Why? The success of Ssemakadde's appeal would depend on whether the Court of Appeal finds that the trial court misapplied constitutional principles or failed to apply necessary safeguards for freedom of speech. Strong arguments could be made, for example, regarding proportionality and necessity. Was, for example, the ruling excessive relative to the alleged offense? How about aspects in light of what they call selective prosecution? Was the case politically motivated? How about issues in light of what they call procedural fairness? Did the trial adhere to fair trial standards under Article 28 of the Constitution? So if the Court of Appeal, for example, overturns the ruling, it could vindicate Ssemakadde to strengthen judicial independence. However, if the conviction is upheld, then it would raise concerns about whether judicial decisions are being used to silence outspoken legal figures.